Welcome Till Death Do Us Plan, the podcast where love, life, and legal planning all come together.
We're your hosts. I'm Santos Vargas.
And I'm Patty Vargas. We're both attorneys and husband and wife.
Each week, we'll tackle the real conversations people often avoid, from estate planning and probate to prenups, postnups, and everything in between.
We're here to help you plan smarter, protect what matters, and feel more confident about your future.
Because life is unpredictable.
But your plan doesn't have to be.
Let's dive right into it. Today, we're talking about the top 5 things to avoid before starting your estate plan. Number 1 on the list is using cookie cutter estate plans. So let's talk a little bit about why it is that for most people, using a cookie cutter estate plan that they find online or they find somewhere else just generally isn't a good idea.
No, you're exactly right, Santos. Cookie cutter estate planning documents really do not achieve the goals and objectives that a client is looking for. Unfortunately, oftentimes those documents are just sort of a plain vanilla what a person may need. However, it's not really incorporating specific terms or other concerns that a client may have that are so critical to having your estate planning documents really reflect and mirror what your intent, your objectives, and your goals are.
So let's say I go online, I find a will or some other estate planning document, has a kind of a fill in the blank type format, and I decide to kind of go through that and just kind of fill in names and fill in maybe percentages or maybe fill in a specific asset or two. Does that mean I'm protected?
It doesn't, quite frankly. And I say that for a couple of reasons. First, because those documents sometimes are themselves quite confusing. The other thing is that I oftentimes see that clients will not execute those documents correctly. And as a result, the entire plan is not in effect. For example, sometimes clients will come to me with a document that they found online in which they not only printed out the document, but then they started to handwrite certain terms. That's not going to be valid in Texas, and it's likely not going to be valid in other states. But more than that, the client's goals, whether it be a need for a trust for a child or other individual, is not really taken into consideration to the extent that it should be, as it might be otherwise when they meet with an attorney.
So let's say let's say somebody finds this type of document online. It's a cookie cutter plan, kind of fill in the blanks, but they have really kind of specific goals as to certain conditions that they want met, and they want to make sure that certain things are fulfilled before one person gets X or another person gets Y, another person gets Z. And so will that type of cookie cutter estate plan protect that person and make sure that their wishes are fulfilled at the time of their death?
No, in a simple answer. And I say that because that's the type of drafting where an estate planning attorney's experience and knowledge really comes into play, because you want to make sure, where are those assets going to come from? If a client has all of their assets tied up in a retirement account and they don't have sufficient liquidity elsewhere, we're not going to be able to make those gifts. And that's a conversation that really needs to be had between the attorney and the client. And so overall, I would say that cookie cutter documents are really to be avoided, because although you think you may be getting what you want, you're probably only getting as much as what you paid for, which was probably not very much.
But can I solve that if I go in, let's say I get a Word version of a cookie cutter estate plan, and then I go in myself and modify it and kind of strike through a couple of provisions and type in some additional provisions that I think mirror what my intent is. Can I solve it that way?
I would have caution about that. And I say that because in the event that your will cannot be interpreted, what you're looking at is, after you pass away, your executor or perhaps one of the beneficiaries is going to have to go to court and ask that the court interpret what it is that you intended. And so when a person tries, even if it's their best, to put in the language, the terms that they need, sometimes it's not done in a way that, legally speaking, is easy to follow. And so by having an estate planning attorney work with you, make sure that those terms are drafted in the order that they're intended, in the way in which they need to be, you can avoid, and your family, quite frankly, can avoid a lot of headache and a lot of expense at the back end after you pass away, when those documents, even if you modify them, are not done in a way in which it's easy to understand and that there aren't any disputes about what it is that your tent is.
And how do non-probate assets play into this conversation? In other words, if I go online, I find a kind of a cookie cutter estate plan, but I have I have assets that we're going to fall outside of probate. How does that kind of factor in to whether or not I have a cookie cutter estate plan? And my thinking is, look, if I have assets that aren't going to be subject to probate anyway, why does it matter? Why does it matter that I have a cookie cutter estate plan? Because all of those other assets really don't apply to what my estate plan that I found online says.
Because it's really important that your non-probate assets, and I often think of retirement accounts or life insurance policies and sometimes bank accounts that are styled as pay on death or joint tenants with rights of survivorship, your estate plan may include and may need to include, for example, trusts for minor children or trusts for individuals who are unable to manage their assets, or maybe who have substance abuse issues. And so if you have non-probate assets, such as a life insurance policy, where you've named that child as a beneficiary upon your passing, and you are not naming the trustee in your will as the beneficiary, the whole purpose of making sure that those assets are managed, administered, and distributed to or for the benefit of that minor child or that individual who has special needs or substance abuse issues, you're completely missing that. And so with working with an estate planning attorney, he or she is able to take a look at what your non-probate assets are, what your probate assets are, and then the overall estate plan to make sure that everything is working together the way in which it needs to and the way in which you want it to.
So have you ever seen, or have you ever had clients come in, or potential clients come in with an estate planning document, whether it's a will or a trust or maybe some other estate planning document that their loved ones found online, filled out, and had executed? Have you ever had those heirs and those loved ones come in with a false sense of security that they were protected by that type of document? And have you ever come across, on kind of a parallel path, situations where that in fact didn't happen?
Definitely. An example that comes to mind is one in which it's a document that is available online. I think in theory, what was anticipated was that the person who was drafting their own will was intended to type in the names, the information that they wanted, but they didn't do that. What they did was they printed out the document and they started to handwrite the terms that they wanted. The result is we don't have a valid will. Separately, there's oftentimes situations in which terms are put, I'll say, almost out of order. And so circumstances can arise where maybe something is not to happen until, let's say, both spouses are to pass away. However, the way in which the document is drafted, it will result in that beneficiary receiving the asset even if their surviving spouse is still alive. And so it really takes kind of that careful eye, looking at the document, again, understanding what the client's goals are. But yes, I've definitely come across those situations, and then working with the family and trying to correct what was intended, what needs to be done, is a lot more costly and a lot more time consuming, when the easiest thing would have been to just come in and meet with an estate planning attorney at the front end. And so the last thing we would want is for somebody to have this false sense of security that they've got this estate planning document that's sort of cookie cutter, and yet it's not really achieving the goals or providing the protection and the necessary terms that the individual is wanting with their estate planning documents.
Number 2 on the list is assuming your family or your friend's plan will work for you and your family. So we talked a little bit earlier about the importance of having a lawyer draft an estate plan for your specific needs. and why it's important to have a lawyer do that. But if my family member or my friends had a lawyer draft an estate plan, why isn't that just good enough for me? I mean, in other words, we've got all the correct legal language in there. We had a lawyer look over it, and it was good. So why can't I just take that and then use that same document for myself?
Honestly, I think a lot of the same concerns with cookie cutter documents apply here, but it's a little bit different because I think sometimes clients say, well, my brother or my sister, we're sort of the same. We have this circumstance or we have these types of assets. So surely what works for them is going to work for us. But that's not really the case. Every family is different. And really every plan, although may be similar, they're not exactly going to be the same. And so whether it's we've got, again, a child with substance abuse issues, maybe we have a child with special needs. Those are very technical types of trusts that need to be drafted for a child who is receiving needs-based benefits. And without the requisite language in your estate planning documents, that child will be disqualified for those benefits.
And how do trusts kind of work into this conversation?
So trust really can come into an estate plan for a variety of reasons. But with respect to what we're talking about right now, what I often find is I'm drafting trust primarily for minor children, and even after a child is 18, 19, 20. I think for our family, I would not want our own children to have sort of unfettered access to assets. If heaven forbid something were to happen to us and any one of them were, 18, 19, and 20. The pressure.
Although sometimes it feels like they already have unfettered access to our assets.
I know, exactly. But when you think about it, you have, someone who is hopefully, starting their career, they're out of high school, maybe they're getting their first job, or maybe they're in college or trade school or something like that, but you don't want them to be taken advantage of. And so having a trust in place is critical in those still formative years. And so at some point, they'll probably become their own trustee. But circling back again, just because there's a trust in a family member's document or a friend's document, it may not be the type of trust that is necessary for your family. Again, a child with special needs who may be eligible in the future or may be receiving needs-based benefits right now, it is critical that a special needs trust be created. Another term that might be important is a substance abuse provision. I think we'd all like to hope that our children are not going to be susceptible to that. And yet, if there's a family history of that, or maybe you just have concerns for whatever reason, having that type of provision in there where a trustee is not required to make distributions to that child until they undergo some certain testing, that may be important. And so it's really, really critical that you just don't say, hey, can you send me your document? I'm just going to, modify it with my family's names. It really, really is important that you meet with an estate planning attorney and you just don't piggyback, if you will, off of a family member's document.
Okay, so now we're going to throw estate taxes into this conversation. If I go out and I use my family members or my friends or another person that I know that I trust, I use their estate plan as my own, how might I be putting my own family's assets in peril when it comes to estate taxes?
Sure. And estate taxes, admittedly, is a pretty complicated subject that I know that we will talk about in greater detail in a future podcast. However, at its fundamental point is this. If your family and the assets that you have acquired either through inheritance or through your own hard work and effort is such that we need to really be planning for estate taxes, if you use another family member's will where they do not have those types of assets, then you are potentially subjecting your family to an incredible amount of taxes. The amount is 40% when those assets are over and above what is in the lifetime exemption amount. Somewhat of a technical term, but I think the key term here is 40% of your assets will be paid to the government. And with the proper planning in place, we can certainly reduce, if not completely avoid, the government receiving 40%. And so it's that type of estate tax planning that may be critical to your situation, that even though, your brother or your sister, they have kids as well, but in your circumstance, maybe there are reasons why we need to really take into consideration terms that are going to pertain to estate tax planning instead.
Number 3 on the list, hiding facts from your attorney. So let's say somebody has a fact that maybe they find a little bit embarrassing, maybe something that their spouse or their children don't know about, and they're worried that if they disclose these facts to their lawyer that's helping them with their estate planning, that at some point is going to get out and that information is going to trickle down to either their spouse or maybe their children or other loved ones. And so they decide, you know what, I'm just not going to tell my lawyer about this. Why is that always a bad idea?
It's a really bad idea. Your attorney is only able to provide the best service they can to you if they know all of the facts and if you are forthcoming with them. And I appreciate that, especially in that first meeting, you may be meeting this person for the first time. And yet it's critical that you have the ability to have those conversations with your attorney. And so you mentioned, for example, maybe there was a child born, prior to the marriage or out of wedlock. It's important that the attorney know that, because as an attorney, I have to make sure, and I usually am doing this during the first initial consultation, that my client has the requisite testamentary capacity to execute their estate planning documents, particularly their will. What does that require? That requires that the client know what their assets are. And I'm not talking about every pot and pan. I'm not talking about they need to know the exact dollar amount in their bank account, but just overall, what is it do they own, and what's the estimated value? Second, they need to be able to know who they can leave their assets to. And if you omit a child or a child's name in a will, that can be incredibly problematic and open up that will to a potential future contest, because it's some indication, if you've not identified them, that you didn't know about them, and then it could sort of trigger this question of whether or not the individual had the requisite capacity to sign their will. The other two, just briefly, is you need to know what a will does, transfers your assets after your death. And then finally, the fourth one is holding all of that information together in your mind at the same time when you sign it. But again, circling back, having that open line of communication with your attorney is incredibly important, because as an estate planning attorney, I'm not only looking very hard to make sure that my client has a requisite capacity, but that they're telling me everything that they know, or that they are able to share with me, because I can only do as good of a job as they're sharing that information.
Well, sure. And what I always tell clients is, look, I can't effectively represent you as your lawyer if you don't tell me all of the underlying facts. If there are facts out there, even bad facts, I can deal with those. That's my job as a lawyer. But if you don't tell me those facts, then all of a sudden I just don't have enough information to effectively do my job as a lawyer representing you. And so I'm sure you've seen this come up with people not disclosing maybe the fact that they have a prenup or a postnup agreement whenever they come to see you. And so tell us a little bit about how those types of factors kind of play into this.
You bet. And a prenup or a postnup sometimes are documents that you may sign before or after marriage that are going to set forth how the assets are going to be handled, administered, and distributed upon the passing of either spouse, and even in the event of divorce. But without knowing what those documents say, I might run afoul unknowingly if I'm drafting a document that says, for example, I leave my life insurance policy to my surviving spouse, but perhaps that prenuptial agreement has language in there that says I'm going to leave this life insurance policy to children before a prior marriage, because that was something that was necessary because it came from a divorce decree. So there's lots of documents that come into play when we start to think about just your will. And so it's important to have those candid conversations with your client. And to that end, I think it's really important that clients understand what the attorney-client privilege is. And I know that's something, Santos, that you work with more day in, day out. And if you could touch base a little on
Sure. Yeah, absolutely. No, there's lots to consider when it comes to the attorney-client privilege, right? One of the things to consider is that whenever you retain an attorney, that lawyer has a duty to make sure that all of the communications that you have with them, all of the information that's shared with them remains confidential. Now, all of that said, one of the kind of complicating factors that can come around on the attorney-client confidentiality and privilege is that if you have a lawyer representing two different parties. So one of the things that people that are kind of looking into estate planning may want to consider is if they're married and they want to make sure that they have somebody that they can disclose information to that's going to be able to maintain that information in a confidential manner, is maybe having an estate planning lawyer for one spouse and then having a separate estate planning lawyer for the other spouse. And that's okay. There's nothing wrong with that. We run into that all of the time where you have one spouse represented by one lawyer, a separate spouse represented by another lawyer. That doesn't mean they're going to be adversarial to each other or fight with each other. That just now means that you have two lawyers kind of working together to represent their respective clients' interests. So one of the things that's really important to consider is that if you do have the same lawyer representing both parties on estate planning, one of the things that could come along with that is potentially having that information that one party shares to that one single lawyer disclosed to the other party. So if one spouse wants to make sure that there's information that's not disclosed to the other spouse, they probably should get their own lawyer to make sure that that lawyer is not breaking confidentiality, and then have the other spouse talk to their own separate lawyer. That way, both parties are protected when it comes to confidentiality, speaking with their respective lawyers.
And that's a really good point, Santos. And I will say that in my own practice, my engagement letter to my clients specifically states that I am not going to keep confidential information that one spouse shares with me. Because for me, I find that puts me in a very awkward position. And so what I say is, we're going to have open lines of communication. If one spouse contacts me, I'm going to be able to contact the other spouse and say, this is what we're doing. This is how things are changing. Because for me, I very much need to make sure that I am not in breach of any sort of client confidences. And so to Santos's point again, if need be, one spouse can have one lawyer, the other spouse can have another lawyer, and it's not that it's adversarial, it's just that there may be some other underlying reason that we need to have two attorneys who, quite frankly, can work very well together and can work in tangent almost while still not disclosing their own respective clients' confidences, and yet move the couple forward in order to get those estate planning documents that they need in place.
Number 4 is avoiding tough conversations with your spouse or your other loved one. So let's talk about why it's super important whenever you're getting ready to start your estate planning journey to make sure that you're ready to have those really kind of tough conversations. So let's talk about what some of those conversations and topics on what those conversations might look like.
You bet. I think oftentimes, and I would say more often than not, when I'm working with clients and it's a married couple, what they are anticipating is that one spouse will serve as the executor for the other spouse and will be named as the first executor or administrator in that will. But that's not always the case. And it may be for a variety of reasons, none of which are necessarily bad reasons, but just, really important reasons. Perhaps one of the spouses is starting to have some issues with memory loss, or maybe they're not someone who is really able to step in if the other spouse passes away and has sort of the wherewithal to hire an attorney, address, any tax filings, help the attorney and engage the attorney and attend court hearings. If that's the case, it is not a problem. We can certainly identify another family member, but you don't want that spouse to sort of be blindsided, if you will, if they just assume, well, of course I'll be named. It may be necessary. There may be some really good reasons why The spouse is perhaps maybe not that best person to name as the executor. The other really big one that I see for families that have children is that difficult conversation regarding guardians. And I know that you and I have had that. And what I like to tell clients is really, as best you can, have that conversation. Let's get something down in writing, and then we can always change it. We can change it the next day. We can change it a week from now. We can change it 10 years from now. And you and I have actually done that before.
And specifically, what we're talking about is guardians for minor children. So let's say that, in the unfortunate event that both parents are gone, right, and there still happen to be minor children in the house, who is it that, in the event both parents die, would then take over responsibilities and being a guardian for that children? So I just want to make sure that we're on the same page with our audience and they understand what we're talking about here. This is, look, that's a really, really difficult thing to talk about. A lot of people don't want to think about it even, but it's really, really important because, from time to time with certain families and certain situations, that unfortunately happens. And if the parents are on the same page as to what's going to happen, they're forced to kind of have those tough conversations, those really kind of difficult thoughts that kind of come into play, thinking about what happens if, both, I and my spouse are gone. Who is it that would be best suited to take care of our children? Their children are going to be in a much better position if both parents have discussed it, both parents have come to an agreement, and both parents really kind of truly understand what they want to happen in the unfortunate event that something were to happen to both of them.
And the worst case scenario is, if that decision is not made, is that if, heaven forbid, something were to happen to you and your spouse and you have a child who is under 18 or is otherwise incapacitated, is that you potentially have a situation where you have family members coming in and fighting about it. And so now we've got a situation where the children are stuck in this sort of limbo position. They've just lost both of their parents, and now money is being spent with this fight as to who is to be the guardian. And it may be people that you don't want to serve as the guardian. So in this situation, you get to choose. You and your spouse get to make that decision together. And it may be a decision that changes over time. I know that we've made that change. As the children were younger, it made sense to name a particular couple. But as the children got older, they became more busy, and other factors came into play, and so we needed to make that change. So it's maybe not a conversation that you're just having once. I would anticipate you're going to have it until the last child is probably 18, but it is so critical that it's had, because the last thing that you would want to have happen is this awful situation where both parents have passed and now there's nothing but infighting amongst the two sides of the family, fighting over who's going to be the ones that are going to get to raise your children.
The other kind of difficult scenario that we oftentimes see in the kind of difficult conversation that we think needs to happen oftentimes between a spouse and the other spouse is the idea of gifts to someone outside of the marriage. And what do I mean by that? That means gifts to somebody other than the other spouse and gifts to somebody other than the children that were born within the marriage.
That's exactly right, Santos. When we've got situations that involve gifts to someone other than the surviving spouse, because again, I think that's sort of the default, the automatic expectation. And yet, if there's gifts that'll be made to someone else, sometimes I've got clients who say, you know what, my parents, I've cared for them, provided for them even financially throughout their, adult lifetime as I was, an adult. Maybe we need to make sure that there's this carve-out gift to the parents and that that's being made. And so those, again, are conversations that are tough to have between spouses, but it's really, really important that those are had so that once you're ready to meet with the estate planning attorney, there's a little bit of a more comfort level of doing that. And I will guarantee you that there's probably some guidance, examples that your estate planning attorney can share with you. So don't feel like you need to come in with all of the answers. It's just important that you have the ability to have those conversations, even if they're tough, with that estate planning attorney.
Number 5, promising things that fall outside of what's in your estate plan. So let's talk a little bit about why it's generally just a bad idea to promise your spouse, your children, or other people things or assets that fall outside of what you've asked your lawyer to include in your estate plan. Why is that a bad idea?
It's a bad idea because those comments that you make really do stay in someone's mind so that they are waiting until your will is probated to see what it is that they're going to receive, and specifically that asset that they heard you say they were going to get. And if it's not in there, or if it's not in there in a way in which they expected or perhaps understood or misunderstood you to say, there can oftentimes be issues. The most significant issue, of course, being a will contest.
It also leads to hurt feelings, right?
Oh gosh, for sure. Definitely.
And do you find that people's memories sometimes differ on what they think they heard somebody say versus what somebody else may have thought they said?
Yes. And I think in part it's because what the client may say to this individual and what's actually drafted by the attorney who's working to carry out the client's wishes, are in fact a little bit different. And so while I know it's perhaps something that you are wanting to share with those family members, I think it's important to be cautious about the language that's used so that, again, there's no misunderstanding, there's no hurt feelings, and worst of all, there's no litigation that arises because of those comments that are made that are misinterpreted or otherwise, not reflected as set forth in your will.
And that's what we see a lot, unfortunately. And I can't count how many times we've had people that have had to spend thousands, if not tens of thousands, and sometimes even hundreds of thousands of dollars on litigation because you have family members who don't agree. You have family members that remember mom or dad said this. Mom or dad said I was going to get the car. Maybe mom or dad said I was going to get the ranch. Mom or dad promised me the painting hanging over the fireplace, and I'm not going to give up until I get that painting or that ranch or that car or you name it in my hands, in my home, with my family, because that's what was promised to me. And so many times we see families ruined, relationships destroyed, because somebody thought it was a good idea to share or make a promise of some asset or something that wasn't what was ultimately contained in their estate plan. And so generally we just caution our clients to avoid it. Don't do it. Keep all of your estate planning within your estate planning documents. And look, as you see appropriate and you think it's appropriate to share that estate planning document, the document itself with someone, that's certainly your prerogative, but our counsel is generally to make sure that everything that you want executed as part of your wishes upon your death is contained and only contained within the documents themselves. And that's just generally a good way to keep misunderstandings from happening, to keep hurt feelings from arising, and to avoid the tremendous costs and sometimes ruined relationships that can result from the litigation that ensues from some of those expectations that have been built up by somebody saying something that falls outside of their estate planning. And so with all of that said, we appreciate everybody tuning in to Till Death Do Us Plan. Make sure to hit the like button. Make sure to subscribe to the podcast. We have lots of great content coming up. We appreciate everybody tuning in. We can't wait to have you on the next episode. Thank you all